Good evening, students. Welcome you all to Study IQ English. Students, in today's class, we're going to discuss an important topic of criminalization of Indian politics. Students, it is an important topic from the perspective of UPSC CSC. It is also important to understand the rot that runs deep into the Indian politics. Students, recently ADR, Association for Democratic Reforms, has conducted a research and the results of the research are shocking. In the report which has been recently published by ADR, it is highlighted that a large proportion of sitting MPs and MLAs in Indian legislatures have criminal charges against them. You will be shocked to hear that approximately 45% of sitting Indian MPs and 44% of sitting MLAs in India have criminal charges pending against them. Students, these are the people on whom we repose our trust. These are the people on whom we repose our confidence that they will take this nation on the path of development and glory. And as per this report, Indian politics is filled with criminals becoming politicians. In today's class, we'll discuss important nuances that have been highlighted in this particular report. Apart from that, we'll also discuss why Indian politics has been marred with criminalizations. Why criminals increasingly are becoming part of Indian politics. Apart from that, we'll also discuss what are the piece of legislations that have been enacted by the parliament to ensure that criminals no longer become part of active politics. Apart from that, we're also going to discuss some important judgments that have been given by Supreme Court that ensure that Indian politics remain clean from such criminals. See, this is the report that has been published by ADR, Association for Democratic Reforms, recently, and the facts that have been highlighted by this report, they are shocking. They are shocking to the conscience of every common citizen of this country who repose trust on the politicians. Students, the report published by ADR says that approximately 45% of sitting MLAs in India, 45% of sitting MLAs in India have criminal charges against them. That means approximately 1861 MLAs in India have serious criminal charges against them. Apart from that, 1205 MLAs, they face serious charges such as offences against women, including rape, crimes against women, murder, kidnapping, and all the serious offences. Now, students, if we just move on to the state-wise distribution, if you just move on to the state-wise distribution of criminals in Indian politics, we'll find the southern states of Andhra Pradesh and Telangana. In the southern states of Andhra Pradesh and Telangana, we'll find approximately for every one individual or for every two politicians, will have one criminal politician. That means half of politicians in Telangana and Andhra Pradesh, they are facing serious criminal charges against them. In Andhra Pradesh, approximately 56% of sitting MLAs, they are facing criminal charges against them. Now, Telangana is not far behind. In Telangana, 50%. That means every 1 out of 2 MLAs, they are facing criminal charges. And Bihar, with 49% of MLAs facing criminal charges. Now, these facts state the shocking state of affairs of politicians or politics in this country. We have already seen that in Andhra Pradesh 56%, in Telangana 50%, in Bihar 49% of sitting MLAs have criminal charges against them. There is something wrong which is going on in the former state of Andhra Pradesh. As we all know, that before Andhra Pradesh Reorganization Act, Andhra Pradesh and Telangana was one state. Now, if we just combine the data, we will find that out of every 2 MLAs, 1 MLA in the former state of Andhra Pradesh is facing criminal charges. That means something very wrong is going on in the former state of Andhra Pradesh. Now, students, there is one fact that has been highlighted in the report that was published by ADR. It states that in comparison to the national parties, for example, BJP, Congress, Aam Aadmi Party, the regional parties have high proportion of criminals being their members. I'm not stating that national parties, for example, Congress, BJP, Aam Aadmi Party, they do not have criminals as their politician or members. But if we just go on looking at the facts, we'll find that the regional parties, they have high proportion of criminals being the member of their parties. Moving on, till now we have analyzed the trend that was prevalent in the states. Now moving on to the national level, we just move on to the national level, we'll find that the state is no different. At the national level, we'll find approximately 36% of the newly elected Rajya Sabha members. Obviously, Rajya Sabha members are elected by the state parties. That means the parties which are holding power in the states, obviously they elect people to Rajya Sabha. They elect and send people to Rajya Sabha. So obviously, when the state of affairs in the state is very bad, when in states such as Telangana and Andhra Pradesh, for every one MLA, there is an MLA who is facing criminal charges. So nothing better could have been expected for Rajya Sabha. In Rajya Sabha, 36% of elected Rajya Sabha members, they are facing criminal charges, with 17% facing serious criminal charges. Students, I'll tell you, there are certain kind of offences of different categories. For example, if we just look at petty offences, that means those offences for whom the punishment is less than 3 years. Then we have serious offences for whom the punishment is 3 to 7 years. And then we have heinous offences for whom the punishment is more than 7 years. So students, in case of Rajya Sabha, 17% of MPs, member of parliaments, have serious criminal charges against them. Apart from that, if we just take a look at 2024 Lok Sabha elections, we'll find that 16% of the total candidates who contested elections, 16% of the total candidates who contested elections for Lok Sabha in 2024, they have declared that they are facing criminal charges. Now, we have a shocking fact. For 2024 Lok Sabha elections, and the candidates who secured victory in 2024 Lok Sabha election, will find that approximately 251 have declared criminal cases against them. That means approximately 45%. That means in our Lok Sabha, the member of parliament that is sitting, approximately 45% of them have criminal cases against them. Now, we can say that the trend in Indian politics, it is increasingly becoming worse. We'll see that in 2019, 43% of member of parliaments have criminal charges against them. Now, it has risen to approximately 45%. In 2014, 34% of MPs have criminal charges against them. Obviously, in 2024, it has risen to 45%. Something wrong, something terrible is going on in this country, that the people are electing criminals as their representatives. Students, now we have to analyze what is the reason. What is the reason why criminals are increasingly becoming part of Indian politics? Why society is accepting them? Why Indian society is accepting them rather than having disdain for the criminals? Few years ago, I was listening to a very senior bureaucrat, and he was saying that in 1970s or before 1970s, people had deep aversion for criminals. If in a particular locality there was a person who went into criminality or who became criminal, the people did not want to even talk to that particular person. People have so deep aversion for criminality that people used to break all the relations with people who entered into the realm of criminality. But over the period of time, the society has started accepting criminals. And not only society has started accepting criminals, society is also welcoming them. Yes, society is also voting from them. Society is also ensuring that such people enter the domain of active politics and hold important public offices. Now, criminals who are facing charges such as murder, robbery, dacoity, charges of corruption, and offences like rape, sexual harassment. Now, these are the people on whom we entrust the responsibility of safeguarding law and order of the country. These are the people on whom we entrust the responsibility of securing the protection of women. This is an oxymoron. That's never going to happen. Now the people who are the violators of the law, now they have become the protectors of law. Now this is an oxymoron. This is the paradox that the Indian society is facing right now. Now moving on, why in Indian society criminals are increasingly becoming a part of Indian politics? Why Indian voters are voting increasingly in the favor of criminals? There are certain reasons for which criminals are entering into Indian politics. One, electoral system dependence on money and muscle. Students, since the 1970s, when the supremacy of Congress party on national politics was breaking down, and when the regional parties were rising their heads, the criminalization of Indian politics, it became more severe. Because now the regional parties, they wanted to field those candidates who can win them elections, and the people who had muscle power, who had money power, who can use their influence either in the form of force or in the form of money and get votes, now they became favorite for the political parties. So political parties started giving election tickets to those people who can use money power, muscle power to contest election, who can even use illegal methods such as vote rigging, booth capturing to capture votes. Apart from that, identity politics. Identity politics is the biggest bane of this country. Identity politics is the biggest bane of the country. Here, people do not vote according to the track record of a particular candidate. People do not even concern themselves regarding what is the criminal background or whether there is a criminal background of a particular candidate. All they care for is whether a particular belong to our community, whether a particular candidate belong to our caste, and if a particular candidate belong to their caste, they're gonna vote for them irrespective of whether a particular person is a sage or he's a devil. Weak institutional system. Students, in India, governance has not reached to every nook and corner of this society. In India, there are certain areas where the governance is conspicuous by its absence. In those areas, the writ of the state is not apparent. Now, in those areas, it is the musclemen, it is the henchmen, and it is the people who hold control over local politics. Now, these people try to resolve the disputes of the people in their own way and more probably in illegal way. Now people often resort to such kind of people because people know that they will not get any help, any assistance from the system. Students, apart from that, we have a weak rule of law in this country. That means in India, law enforcement remains weak. The judicial system is marred by delays. Suppose there is a person against whom criminal complaints or FIRs are filed. Now the person is facing trial and the trial goes on for a period of 10 years, 15 years, 20 years. In the meanwhile, as the person is not convicted, so that means he is still innocent. And in the meantime, a person can contest elections, he can win elections. So till the time a case is disposed for the first time, the concerned criminal would have won 3 Lok Sabha elections and he would have become the member of parliament 3 times. Now, what are the legislations in India that deal with criminalization of politics, that ensure that criminals do not form the part of active politics? Now, under Section 8 of Representation of People Act, any member of legislature, whether state or central, if a person is convicted for the following offences, whether under IPC or under Protection of Civil Rights Act or under Unlawful Activities Prevention Act, all under NDPS, Narcotic Drugs and Psychotropic Substances Act, or under Prevention of Corruption Act, or under Commission of Sati Prevention Act, or any other offence, the person is disqualified from being a member of legislature. That means he cannot remain the member of legislature further. Now, for the period of sentence, for example, if a person is convicted for 10 years, for the period of 10 years plus 6 years, that means 16 years, the person cannot become a member of legislature. He cannot contest elections for either Lok Sabha or state legislature. Apart from that, if any person is convicted of any offence apart from that for a period of more than 2 years, then the person would be disqualified from holding any position in any legislature for the period of sentence plus a period of 6 years. Apart from that, we'll see the Supreme Court has rendered important judgments that ensure that ensure that criminals do not enter into active politics. Students, Supreme Court has given fantastic judgments. One of them is Union of India versus Association for Democratic Reforms. The biggest bane of this country is identity politics. I have already said that. Now what happens? People sometimes are also not aware that a particular person has criminal background, that he is facing serious criminal charges. So that's why it is important for the voters to know that a particular person is facing criminal charges, so that the voters will be able to make some important and informed choices. So that's why the Supreme Court in Union of India versus Association for Democratic Reforms explicitly stated it is mandatory for every candidate. It is mandatory for every candidate who want to contest elections and who is filing nomination papers to disclose the list of criminal cases against him. That means he has to disclose what are the charges he is facing before a court of law. That means now the voter will be able to understand, the voter will be able to get himself informed of the charges that a particular candidate is facing, and he will be able to make an informed choice. Apart from that, in Lily Thomas versus Union of India 2013, the Supreme Court rendered a very fantastic piece of judgment. Under Section 8 of the Representation of People Act, we have already seen this. Section 8 of Representation of People Act, under which a person can be disqualified from being a member of or from continuing to be a member of legislature if he is convicted of any particular offence. Now, the Section 8 subsection 4 of this particular act, Section 8 subsection 4 of this particular act, on one hand, this section is preventing criminals to be part of legislature. On the other hand, this section is also providing them escape route. How? Section 8 subsection 4 clearly stated, if any MP or MLA is convicted of these particular offences, he will not be disqualified immediately. He will be given a period of 90 days. He will be given a time window of 90 days in which he can file an appeal before the respective appellate court, and till the time the appeal is pending before the court, he will not be disqualified. That means he will be allowed to be a member of legislature. Now, Supreme Court in this particular case, Lily Thomas versus Union of India, specifically stated as soon as a sitting MP or MLA is convicted of committing any particular offence under Section 8, his seat will be vacated. That means immediately he will cease to hold his particular seat. Now that means as soon as a particular MP or MLA is convicted, he is disqualified from being a member of legislature, whether of state or parliament. It's a fantastic piece of judgment because Section 8 subsection 4 was providing an escape route. Now this judgment given by the Supreme Court, it just closed the escape route. Now it would be a big deterrence for sitting MP and MLAs to commit crimes, because now they will know if they are convicted, they will lose their seats. Next, Public Interest Foundation versus Union of India 2019. In that particular case, the petitioners filed a petition before the court and they asked the court to increase the number of grounds on the basis of which a sitting MP or MLA can be disqualified. Supreme Court stated it is not up to us. It is up to the legislature to increase the grounds or reasons that can form the basis of disqualification of MPs or MLAs. We cannot do it. But one thing that we can do it, we can direct the political parties in this country to give a proper disclosure. That means the political parties have to give a proper disclosure, and the Election Commission of India has to disseminate this information to the public if there is any particular person who has been given a ticket by the political party and who is facing criminal charges. For example, Party A, if he feels a person who has pending criminal charges against them, the political party has to disclose this information to the public, and the Election Commission of India also has to disclose this public information and give it wide publicity, so that the people will be able to understand that the particular candidate is facing criminal charges and that particular candidate is devoid of any sort of stigma. Now, as we have read the state of affairs of criminalization of Indian politics, we have read the legislations as well as the judgment given by the Supreme Court that ensure that politics remain clean and devoid of criminalization. Now students, there are certain recommendations that you can also use in your answers, and that need to be followed, that need to be incorporated in Indian legal as well as political system to ensure that criminals do not enter into politics. First, We need to change the legislative framework. We need to change the legislative framework right now. Whenever a person is convicted of committing an offence, sitting MP or MLA is convicted of committing a particular offence, he is disqualified for a particular time period. So the time period of his sentence plus 6 years. This needs to be changed. If a sitting MP or MLA is convicted of a particular offence, he shall be disqualified for the lifetime. That it will ensure that sitting MPs and MLAs, they are deterred from committing any kind of offence. Secondly, there shall be establishment of special courts. The biggest reason for criminalization of Indian politics is that due to delays in justice delivery system in India, the trial is kept pending, but the trial is kept pending and the person is not convicted. Since he is not convicted, so the disqualification does not steps in. That's why there need to be established a special courts. If any MP or MLA commits an offence, he will be tried before a special court. He will be tried before a special court. And secondly, the trial shall be completed within a limited time period, maybe 1 year or 2 years. Now, this will ensure if a person has committed an offence, he will be convicted within a limited time period of 1 and 2 years. Secondly, it is also important that the sitting MP or MLA, or we can say that a person shall not be disqualified as on the time when he is convicted, but he shall be disqualified well before that. The Law Commission of India has given a report. In that report, the Commission has particularly stated that it is important that as soon as charges are framed against sitting MP and MLA. Now, generally what happens in criminal cases, FIR is filed, police conduct investigation, charge sheet is filed, and after that the sessions court or the respective district court takes the cognizance of the offence. Now the sessions court frame charges. Law Commission said कि not from the stage of conviction, but as soon as the session court has framed charges, so from that moment the sitting MP and MLA shall be disqualified. That means from the moment charges are framed by the session court, not from the moment the person is convicted, but from the moment when charges are framed by district court or session court, the sitting MP or MLA shall be disqualified. Apart from that, we shall bring in the concept of state funding of elections. That means now why do political parties give tickets to the people who have money power? Because the political parties want money. And why do they want money? Because they want to contest elections. So we can adopt a method like some Western countries in this world where there is state funding of election. The state itself fund elections. Yes, the state itself fund the elections. That means the political parties will not be dependent on the people holding muscle power and money power to contest election. The state, the public exchequer will fund the political parties to contest elections. Voter awareness campaign. It is a must that civil society organizations, NGOs and people like us, we shall conduct awareness campaigns in which we shall raise this awareness among people that they shall not vote for a criminal. If people know that a particular person has criminal background, the person shall be not voted for. Because sometimes people vote for a particular candidate in lieu of certain sum of money. Sometimes these people who are contesting election, they distribute money. They give bribery to the voters. Now, for the greed of 1,000 or 2,000 rupees, people take the money and vote for these people. But people don't understand that a person who is spending lakhs and crores of rupees for getting elected in a particular election, now he will recover 5,000 times. He will recover the sum 5,000 times. That means the person who has spent 10 crores for contesting elections, for distributing money among the people, now this person will at least make 5,000 crore rupees. That means he will try to appropriate the money that belongs to the public, that is public money, for himself. So this is important for the people to understand that criminals who are using their muscle power and money power in elections, these people will never take the country forward. They will not make this country a developed country. And last, strengthening nota. We have this option in the voting machine, nota, none of them above. But nota generally is insignificant. The number of votes that are voted for nota does not make any difference. And here we have to bring a change. So the Election Commission of India needs to change its rules, and before that the government need to change the conduct of election rules as well as the Representation of People Act to ensure that if Nota gets majority of votes, the election in that particular constituency will be cancelled. The election in that particular constituency will be cancelled. That simply means that people do not like a candidate, or the candidate is facing some criminal background, the people will vote for Nota, and when people will start voting for Nota, and if majority of the votes go to Nota, the election will be cancelled and there will be re-election. Now the parties will be incentivized to support and field those candidates who have a clean background and who do not have indulged in any sort of criminality. So students, I'll end the video here. This is an important piece of video. The data that I have displayed in this particular video, apart from the suggestions, recommendations and the facts that we have seen in this particular video, you can use any of these facts, suggestions and recommendations while writing answer if you ever come across a question that talks about criminalization of Indian politics. This is all for today. We'll meet with a new video. We'll discuss some important legal topic for your relevance, and till then, please take care of yourself. Jai Hind.